The Guyana Teachers Union and the Ministry of Education were back at the High Court today after the union filed an application through the attorney Darren Wade. Senior counsel Roysdale Ford, who also appeared in the matter with Wade, said the application was focused on obtaining documents from the Ministry of Education from 2020 to February 5, 2024 to show that collective bargaining had been discussed with the Guyana Teachers Union. According to Ford, these documents ought to be in the possession of the Minister of Education, the Permanent Secretary, or the Chief Education Officer. Ford said these documents are critical in the resolution of the issues.
Government, through the Ministry of Education, is contending that a number of financial measures which are set out in their affidavit form part of a discussion or collaborative process of negotiation. The GTUC and the GTU, we are contending the opposite, that those measures pointed out in paragraph 15 of the affidavit of Saddam Hussein were unilateral impositions. They are critical for the resolution of this case. It goes to the question as to the legality of the strike and in all circumstances whether the strike would have been justified. And then from that, the premise will lead into other issues in terms of whether the teachers can and ought to be paid for the period when they were on strike.
Ford pointed out that the notice filed by Attorney at Law Darren Wade was withdrawn after Justice Kissoon made certain considerations.
But fundamentally, the pit and substance of the application was to obtain the documents, and that was ordered by the court.
Attorney General Ani Nandalal described the application filed by Wade as ridiculous.
And the whole application was misconceived from top to bottom. The court was very kind and very, very generous to him. The court granted him leave to withdraw and discontinue the proceedings. I was also very kind and charitable to him and to the teachers' union in that I did not seek an order for costs. Then the court proceeded. Now there is a conflict. Mr. Chief Education Officer has alleged a particular narrative in his affidavit. The GTU is alleging a different narrative. So you have two affidavits that are conflicting. In my view and in my learning of the law, the conventional and legally permissible thing to do in those circumstances is that you put the two witnesses in the witness box and you cross-examine them based upon what they have said on the oath in an effort to reconcile the differences. A different method was chosen here. The respondent, who has nothing to prove in the case, has been ordered to produce minutes, which we will do. But the applicant has moved this court. The applicant is asking the court for reliefs. The applicant has to prove its case. The applicant is saying what the respondent is saying is not true, but the respondent now got to come and prove that what he's saying is the truth. Maybe new law, new process, but let's see how it turns out.
According to the Attorney General, the substantive matters are questions of law.
It's whether teachers who did not work and who participated in a strike should be paid. The question whether that question can't be determined by whatever minutes and whatever different factual narratives there are from the competing parties. That is a question of law. No work, no pay. That is the law of Guyana. The other big issue was the government right in stopping the deduction of union dues. That's the big legal issues, in my view. Whatever Saddam Hussein says in an affidavit and whatever Mark Light says in an affidavit can't change the legality or illegality of that decision. So in my view, the court is in charge and I am to comply with the orders of the court.
Attorney at Law Darren Wade said the documents are important to put the Chief Education Officer Saddam Hussein to the test.
If you read the application, I believe it's important to put Mr. Saddam Hussein to the test. The union is denying that at any point there were any collective bargaining, there were any discussion in relation to benefits for the teachers. The union is contending that these meetings are statutory meetings via the 2016-2019 agreement, whereby they discuss issues in relation to policies and classroom issues. It has nothing to do with benefits for the teachers. Mr. Saddam Hussein, in his affidavit, said, no, this is not true. And the application is buttressed on that. You are saying that this transpired, provide the evidence. That is what is that's what the court decided and has asked him to do, to produce his documentation.
The matter will continue tomorrow.